So it's a pleasure to be here, and it's a pleasure to be with this excellent panel, which I think is a very special panel in the sense that though we're going to talk about restructuring and bankruptcy. Very often when you go to a restructuring or bankruptcy panel, it's filled with lawyers or filled with investment bankers. But here we have them all. So, and it's not always, or all judges, but here we actually have judges, investment bankers, attorneys, and then me. And my job is primarily just to keep the conversation going. I'm a professor at the law school. I teach bankruptcy, and at least one of the panelists has taken a course from me. But let me just briefly introduce the group and then use the rest of our time to talk about what is changing in the Brazilian bankruptcy landscape. And we're going to start actually with a lay of the land about trying to just kind of get everybody up to speed about what is special about Brazil versus the United States and what things are going on. And hopefully we'll leave a few moments for questions. And in fact, if you have questions as you go along, I think we'd all be happy to field those questions as we go. So just raise your hand. But without further ado, let me introduce the panel. To my immediate left is Judge Arthur Gonzalez, or I should say former judge. Judge Gonzalez, not so long ago, was a judge on the bankruptcy court for the Southern District of New York, and handled some of the biggest cases you've ever heard of, including Enron, WorldCom, and Chrysler. And so during his years there, Judge Gonzalez was known as one of the most high-profile judges in our country, and we're very fortunate to have him here. And NYU Law School is very fortunate to have him full-time. He's a senior fellow there now. Next to Judge Gonzalez is Frederick Kahn from Metrica Investments. It's an advisory group. And does investment banking as well in Latin America, working on a wide range of issues from private equity raises, structured debt financing, management buyouts. And as I learned in the conversation before, that Fred does a lot of advisory work with creditors, doing work in restructurings in Brazil. Sometimes Fred sits on the opposite side of the table from the person to his left, Marcelo Messer, who is a managing director in the restructuring and debt advisory group at Rothschild, where he advises companies, creditors, and other stakeholders in and out of bankruptcy court. At the far left is Bruno, I'm going to mispronounce it, Kurzweil. Is that close? I'm close. He's a partner at a firm whose names I will also butcher, Tomás Bastos, Weisberg, and Kurzweil Advogados. I think I got that almost right. Bruno's claim to fame is that he was one of my students. And then after that, he says that he's been involved in lots of insolvency. And it seems like almost every important insolvency related matter in Brazil. Despite his young age, he's handled 40 since the change of the law in 2005. And let's actually talk about that. In 2005, Brazil adopted a new bankruptcy law that was designed in part to resemble Chapter 11 of the United States Bankruptcy Code. And we have now about almost 12 years of experience, 11 to 12 years of experience with that. And what I want to do is begin the discussion today by trying to figure out how does the Brazilian law work relative to United States law? And it's a good comparison because in some sense the Brazilian law, by its terms, tries to mimic or adopt some of the provisions of Chapter 11. But instead of asking that sort of in the abstract, I told the panelists I'd like to start by making it a little more concrete. And the way I'm going to do that is through what law professors do a lot, is through a hypo. So let's pretend that we have a firm and it's a corporate group. Let's pretend it's operating in the sector of telecom, and let's suppose that it's a very large corporate group with a parent at the top, subsidiaries at the bottom. The subsidiaries have various functions. Some may hold real estate, some may hold licenses, some may have domestic production, some may have foreign asset holdings. And let's suppose that each subsidiary, as well as the parent, has its own capital structure, meaning that the parent has its own assets and liabilities, and each subsidiary has its own assets and liabilities. Furthermore, assume each subsidiary and each parent, and the parent and each of its subsidiaries are separate corporations. Each one is a distinct legal entity, though they are part of a corporate group. They work together as a corporate group, but they're all different legal entities. As evidence that they're part of a corporate group, let's suppose, as is commonly the case, that the debt issued by the parent has been guaranteed by the subsidiaries. Could be vice versa too, where the parent guarantees the subs. But let's just start with the debt of the parent being guaranteed by the subs. And let's suppose as well that there's two types of debt at the parent level, that there's bonds, which are widely held both by foreign and domestic, but primarily foreign investors. And let's suppose that there is bank debt. And the bank debt is let's suppose, primarily domestic bank debt. Okay, so that's our structure. So parent, bonds and bank debt at the top. A bunch of subsidiaries have their own capital structures, their own employees, their own suppliers. And there's a relationship in the sense that the parent owns the subsidiaries, despite their legal separateness, but there's also a relationship in terms of capital structure, okay, that they're guaranteeing each other's debts. And let's suppose that a crisis has occurred that has caused the company to suffer insolvency. And the question I want to pose to the panel is, like, imagine that telecom company, and let's suppose two alternative universes. Universe one, this company is headquartered in Brazil and has filed for bankruptcy there. Universe two, it's headquartered in the United States and files for bankruptcy here. And so I wanted to ask the panel, what do you think will play out differently depending on whether the case is in Brazil versus whether it's in the United States? And let's use that as an opportunity to play out more broadly what the difference is between Chapter 11 and the Brazilian system. And I'm going to just throw it out to the panel. Anyone who wants to kind of jump in.
I'm happy to start. So first of all, thank you. Thank you for inviting me. It's an honor to speak to this group. I'll start with thinking about how it would likely work in the United States from the first days of the case in the first months. So in the U.S., the company would be given a period of time called an exclusivity period, in which only the company could propose a plan. It's called a plan of reorganization, which is the plan that sets out how all of the various creditors of the company will be treated at the end of the case. Only the company can present that plan for the first 4 months, and that period can be extended by the judge if the company is able to demonstrate at the end of that period that it's made a lot of progress, it's negotiating with its creditors, it's doing all the right things that a company should do in Chapter 11. It's not playing games. And it can be extended for up to an 18-month period. If those 18 months pass, or the judge doesn't extend one of the prior deadlines, then that exclusivity period is over, and that means that other parties in the case, creditors in particular, or creditor groups, can propose their own plans. And if that happens, the shareholders, those who are on the board, control the company, lose a great deal of control, and something that they had that was very valuable in terms of having the control over determining the framework of how everyone's going to be treated, suddenly it's kind of open to everyone. So they really try to prevent that from happening. And to do that, they have to maintain exclusivity, which means they have to either present the plan during the period that they have, or really demonstrate to the court that that period can be extended because they're doing all the right things that a court would want them to do. In Brazil, it doesn't work that way. In Brazil, under the code, only the company can present the plan. There is no situation in which creditors can propose a plan and put that up for a vote, which the practical consequence of that is that the shareholders of a company that has filed for recuperação judicial, which is the Brazilian equivalent of Chapter 11, have a great deal of leverage. Right? They have the ability to drag out a case, to not make that progress that you need in the United States. And another important element of that is that in Brazil, if a plan is voted down, if the company puts forward a plan and the creditors vote it down, the consequence is liquidation. It's not, we can have another plan, let's try something else. The consequence of voting a plan down is liquidation, whereas in the US, that's not at all the way it works. So shareholders in Brazil, and if you think about it, the company is insolvent, the equity is probably worthless. The debt is probably not worth its face value. It's trading at a discount, and the equity is really worthless. They nevertheless have a great deal of power. And so they use it to their advantage, and they say, look, I'm going to put forward a plan that treats the equity in a way that doesn't reflect the real value of that equity, just because it's in their economic interest to do that. And if you guys don't like it, okay, I'll get 0 in a liquidation, but you're going to get 0 too. And it becomes a standoff, and it's something that it's not analogous at all to how it works in Chapter 11. So that's one difference, and there are others.
Go ahead. I think you have the red light.
There.
Okay. Thank you, Marcelo. Thanks.
Pass the mic.
Thank you all. I also appreciate the invitation. I'm part of the alumni group. I was here in the LLM. I graduated in 2012, so it's an honor. Another different, I think, Marcelo, would be the discussion about substantive consolidation. I don't know, Professor, if you want me to try to explain a little bit what that would be. In the case the hypo professor brought us, there's a group of companies that filed together for a restructuring proceeding in Brazil. So one of the first issues that would be debated in the proceeding, it would be if the plan would be consolidated or not. Meaning that if the plan was to be consolidated, all the creditors of the different entities would be treated the same in each of the classes. They would be treated pari passu within the classes. Hi, Richard. And if the judge, by any chance, doesn't allow the subcon, each of the companies of the proceeding would have to present its own plan and to treat its own creditors in its own way. So I think that the first thing in Brazil, it's the Brazilian culture about a group of companies. Brazilian companies, they are most likely to be controlled by the same shareholders, even B groups, so it's really usual for the same shareholders to be the controlling shareholders of all the companies of the group, and they treat each of the company as an entity for the benefit of the group. So it's much more common in Brazil to see each of the company making business to the benefit of the group instead of each of the operating companies to try to benefit for itself. So it's part of the Brazilian culture. We have lots of decisions in favor and against the subcon, but most of the decisions, they try to rely on that cultural issue in Brazil, that a group is always a group, and the group is a single entity. So, and I think that it would probably be seen in a different way here in the U.S. In the U.S., each company would have to likely present its plan, and the subcon would be allowed only exceptional cases where the group can effectively show that it is operating, and it has been operating as a single entity from a long time. So I think that's another difference between these.
On the subcon,
Judge,
I agree.
can I, sorry, I don't want to, I'm sorry to stop. I just want to take a quick breather because we're just joined by our final panelists. And I'm sorry to begin without you, Mr. Graham, but let me just take a pause to introduce. So Mr. Richard Graham is a partner at White & Case, and he fell victim to what many of us have fell victim to, is the New York City subway system. So we're glad you could make it up. Mr. Graham is a partner in the financial restructuring and insolvency group at White & Case, and brings one of the expertises he brings to this panel is cross-border insolvency practice. So I'm sorry, Judge Gonzalez, let me turn it back to you. There you go.
Okay, I should have paused myself. I was going to address both issues that were raised. One, the subcon is true. In the U.S., it's much more difficult to substantially consolidate. There is a great deal of deference given to the separateness of the corporate entities, and the burden would really be on the debtors to establish, and there are 3 or 4 leading circuit cases, but even in the most liberal circuit case, it wouldn't be as easy as what may be described as kind of the cultural view of this is one entity, all in it for the greater good of all. That is not the way the U.S. structure would be, and you would generally have to show a separateness in the way people were dealing, an inability to untangle a mess effectively that may occur as books and records may not have honored that separateness. So it often comes as a threat in a U.S. bankruptcy case, a substantive consolidation, and may drive a settlement under a plan, but there aren't that many cases that actually do substantive consolidate over the objection of creditors. And I wanted to go back to the first comment about the difference in the systems. The U.S. system certainly seemingly has a great deal more of a balance as between creditors and the debtors and the rights. And equity doesn't have a great deal of power, has some power through exclusivity, et cetera. But I think that power has been significantly lessened over the last 5 to 10 years because most of the large cases coming in, and not all, are fully encumbered with secured debt. And having been fully encumbered with secured debt, the secured creditor has an awful lot of leverage in the case and may well have replaced management with a chief restructuring officer, et cetera. But it has a great deal of more, I think, impact in the way the process plays itself out than even historically how Chapter 11 was originally designed with exclusivity for the debtor, equity, et cetera, and then counterbalancing creditors' rights to terminate exclusivity and present their own plan. I think today's world throws more power into the creditors and predominantly the secured creditor.
Can I pick up on that? There's a theme that's emerging here, which is that at least as Marcelo and Bruno pointed out, that there's a power that equity holders seem to possess in Brazil that they do not exercise as strongly here. One is they can control the case and not subject to the limits. Like Marcelo talked about the exclusivity period, that at a certain point, shareholders face the prospect that creditors can propose their own competing plans of restructuring. You say that can't happen in Brazil. And Bruno's saying that in the United States, there's a strict separation of entities, that corporate separateness is respected, and that gives creditors power in negotiations, that the parent company may feel it needs access to assets held in a subsidiary, but creditors can deny access to those because those are technically in a separate corporation. So that's the equity versus creditor, the shareholders have power, but in the United States, I think as Judge Gonzalez is saying, that over the past 5 to 10 years, we've seen the rise of the secured creditor and the rise of creditor control. In the 1980s, it was thought that bankruptcy in the United States was also dominated by equity holders, but now it's thought that creditors have gained control, and I thought part of that story, and correct me if I'm wrong, Judge Gonzalez, is a rise of just the need for liquidity. When a firm comes in with liens encumbering all of its assets, usually it's lost all of its cash, and because the remaining assets are encumbered by liens, it can't borrow against them. So it needs cash desperately. And if you come in needing cash desperately, well, you got to get permission from your creditors to borrow more or to have them release their liens. And so that gives the creditors tons of control. So I wonder, is there a phenomenon like that in Brazil where the desperate need for cash is king, gives creditors some power to fight back?
Absolutely. Well, the cases where creditors have been most able to get results that are different than the norm in Brazil, in other words, get better recoveries, are when the company's running out of money and they're the only realistic source of cash, and therefore the leverage that they exert has nothing to do with the legal system or the code, and it's entirely economic leverage from having cash when the company needs it and no other real sources for it. So OGX, for example, was a situation just like that. OGX was one of the companies owned by Ike Batista, was that big, very wealthy, formerly wealthy individual in Brazil. OGX was his oil and gas exploration company. And when, in the months preceding the company's filing for the recuperação judicial, the Chapter 11 in Brazil, it was clear the company was running out of money. Their advisors had run a process to raise capital from, they knocked on everyone's door, private equity funds, hedge funds, banks, you name it. Everyone said no. the creditors who were U.S. bondholders, were predominantly the debt of the company was U.S. bond debt, offered cash to the company more for their own, to defend their own position, because they were really the ultimate economic stakeholder. And they did so with terms that were the kind of terms that a typical unsecured creditor in Brazil would never, ever get. So I believe it was that they assured themselves of getting 60% of the equity of the company once it emerged, which is a much higher recovery than unsecured creditors typically get in Brazil, and it was entirely born out of the fact that the company needed cash and they were the only source of it. So Ike Batista, in that case, his stake was diluted down to less than 10%, which, for typical shareholders of a Brazilian company going through that process, it's typically the exact opposite in terms of how the recoveries stack up.
Do you see that firms in Brazil increasingly have, like phenomenon in the United States is that distressed firms take on lots of secured debt, and by the time they go into bankruptcy, they're kind of leaned up. Liens are, secured debt covers most of the assets. Is that a phenomenon in Brazil, or do many firms in Brazil enter bankruptcy with free assets, assets unencumbered by liens?
Can I
Yeah, go ahead.
Yeah, actually, no, it's normal for the debtor to have all its assets encumbered, and I think there are two elements in Brazilian restructuring proceeding that that for the debtor is harder to manage a restructuring than here. First is you can't prime any secured creditor in Brazil. So even if a creditor has 200, 300% of collateral as guarantee, you can prime the creditor to get new money. You can do that.
You can or cannot?
You cannot.
Cannot.
You cannot do that. And second, you do have some guarantees in Brazilian proceeding that are totally excluded from the restructuring proceeding. So you have something called alienação fiduciária, like a fiduciary lien, that the creditor can, during the restructuring proceeding, foreclose on the guarantee. Of course, that there are discussions between creditors and debtor to when and how to foreclose on the collateral, but in theory, these guarantees, they are excluded from the restructuring proceeding. That, in my view, I agree that there equity holders in Brazil, they do have lots of leverage against creditors, but that's the other side of the coin. We do have some guarantees in Brazil that do give creditors leverage against the debtor.
Can I bring Fred into the conversation? I want to ask you a question, and maybe you can, if you don't want to talk, if you want to talk about what was talked about before, that's fine. But I want to kind of shift it a little bit. That we've been talking a lot about creditors versus shareholders, but I mean, we talked recently about the idea that within the creditor group there can be conflicts of interest. And so in my hypothetical, we had a parent company with bonds and bank debt, and I think you've seen that even among that group there can be differences of opinion that matter to the shareholders.
Yeah, that's typically quite true. I think when you look at the capital structure of a typical Brazilian company that has bonds and bank debt, the bonds are typically held primarily by an international investor base that is much more used to a U.S. style or a developed world bankruptcy process, where typically they will consider restructuring options such as a debt for equity conversion, looking at the solvency of the company on a post-restructured basis, trying to take it to a place where the balance sheet is healthy to allow the company to remerge and restart without being under a mountain of debt. In Brazil, what you typically see is you'll have international creditors that are willing to look at such options, debt for equity, but the banks are still very much stuck in a little bit of what we like to call a pretend to extend kind of mindset. And that has to do with their desire to try to minimize write-offs. And it also speaks a little bit to the issue of successor liability. In Brazil, Marcelo mentioned OGX. In that case, it was a publicly listed company. And in a publicly listed company, you would typically have less of a successor liability issue where you're not, perhaps, as an individual creditor once converted, stepping into the shoes of what was a controlling shareholder or a significant stake with significant influence. But in private companies, that's usually not the case. And so going from debt to equity, you start running the risks of inheriting all kinds of successor liabilities ranging from tax, labor, environmental, that effectively can pierce the veil and put your other assets as an institutional investor, say you're a large institutional investor with multiple assets in Brazil, all of a sudden you start tainting everything else in your portfolio. So, and that is also true for the banks. So the banks sort of culturally really resist converting from debt to equity. They also resist haircuts for the purposes of markdowns. And so you get this issue where it's really tough many times to actually craft a capital structure for the company that allows it to come out from under a mountain of debt and actually recuperate. And it's one of the reasons why in Brazil, many of the companies that emerge from recuperação judicial actually never get a real shot at a second life. And I think, as some of the practitioners and judges and lawyers that I talk to think about the future of the law, that's one of the key issues that they're trying to tackle. It's how do you work on the banks to look at the system from a different perspective to breathe new life into these companies.
Just a comment on the banks and never having worked for a bank, I don't know if I'm right, but the U.S. banks used to have a similar mindset. I mean, if you went back in the 80s and 90s, banks didn't want to own equity then either. And if you look at the traditional U.S. bank today, it still doesn't want to own equity. But what we call bank debt, I think in today's market, is not really bank debt. The bank is only the agent bank, and everybody underneath it that put the money in is much more likely to fall out of what the definition of a traditional bank would be, and more of an equity investor type hedge fund willing to take equity on the back end of a transaction. So it's a very different, although we use the same word, I think it's a very different entity, today's bank versus banks in the 80s and 90s.
And to that point, one of the big discussions that the market's having in Brazil is how to actually nudge these banks, and there aren't many, the banking system is highly concentrated, to start thinking about selling portfolios of non-performing corporate loans or single names. And that's a process that's still been slow to develop, but as the value of NPLs mounts, especially on the back of this most recent crisis, what we're hoping to see is more activity in that space. And hopefully with that, you'll see credit funds form or international credit funds play in that space and try to facilitate the process.
Okay, so let me just take it back to the panel. So one of the themes we're trying to unearth is just what are the fundamental differences between, you've law in Brazil and law in the United States that on the books at least look like they're trying to go to the same place. In practice in Brazil, we're finding that there are some major differences. We talk about substantive things that affect the dynamics of the bargaining, substantive consolidation, equity holder ability to extend the process. But we also see that there's some developments that are similar to the United States, that cash is king, that gives the creditors more leverage. To the extent you have a more liquid market for debt, that's going to actually affect whether banks, when banks can sell their positions, and you don't have to worry as much about conflict among the banks being more patient, wanting to pretend to extend, and bondholders and hedge funds wanting something else. So you might get more convergence with this more liquid trading environment. So part of the story is that there have been differences. Maybe those differences are kind of potentially reducing over time. I just wonder, are there some immutable differences? I thought, for example, Marcelo, I thought you mentioned that, maybe it was during a phone call, that the ability to cram down equity is different in Brazil.
Yeah, there is no provision in the code in Brazil that lets you cram down equity, and it's kind of bolstered by the fact that you need equity to propose the plan. So how likely is equity going to propose a plan that gives itself zero? But separate and apart from that, there is no provision in the code that lets you force a effectively zero recovery, which is the norm in the United States. for most Chapter 11 cases. There is no analog of that in Brazil. And while we're on the topic of differences, one that we haven't touched on, which is I consider a pretty significant one, is in Chapter 11, and this is often a solution in Chapter 11, what I'm about to describe, you have the ability to sell businesses out of bankrupt Chapter 11 companies, whether it's a division of such a company or it's the entire company. It could be the entire set of assets. There's a very sophisticated set of provisions in the code that govern how you can sell that while the company is in Chapter 11, so that, let's say you have a group of creditors it's very complex, the capital structure and corporate structure, and there's a lot of disputes and litigation. And meantime, while creditors are fighting, the business is suffering. Say it's a retail brand or something that is really suffering by being in Chapter 11. Oftentimes, the solution is, well, let's sell the business so that it no longer suffers, and let's maximize the value that we can get from this collection of assets. And then we'll have an amount of cash in the estate of the Chapter 11 company. You guys can fight over that. The cash doesn't suffer by being in Chapter 11. Oh, sorry.
Should work.
Now it does, sorry. So that's often a solution in Chapter 11. Let's sell the business. We're better off realizing as much value as we can, not let the business erode, and let creditors fight over the cash that remains in the estate. Well, in Brazil, there are provisions for selling groups of assets and selling businesses, but they come with a twist. One of the twists is that the creditors have to agree on how the proceeds are going to be split up and divided up amongst them before the sale takes place. Well, that kind of defeats at least one of the purposes of being able to sell businesses out of a bankrupt entity, which is what I mentioned of it might be eroding, it might be deteriorating, and let's leave the fight for later. Well, in Brazil, you need to have the fight first. So that's one problematic aspect of it. Another one is under the Brazilian law, you can't sell the entirety of the business. You have to leave behind, in Chapter 11, a viable, quote-unquote, economically viable set of assets. And that's not a well-defined term, but it's there. And so that eliminates a solution which is often found in Chapter 11 cases where we're better off selling this whole business and let's fight over the cash. So I thought that it was important to bring up that difference as well, because you see it, I'd say, increasingly in the United States as capital structures get more complex and corporate structures get more complex. The scope for creditor disputes just goes up, and the solution, therefore, tends to be, well, let's sell this and leave the disputes for later.
And on that point, back to the issue of successor liability, it's also a problem when trying to dispose of assets. You can have assets take with them tax liabilities, for example. So this concept of a liquidation of inventory that you might see, for example, in a retail scenario is potentially difficult to execute in Brazil. There are some U.S. firms that are now trying to get into that business and looking at possible angles of how to do it. For example, in the case of inventory, if you liquidate it and you sell one item to one person and it's virtually impossible to track who bought the item, maybe the issue of successor liability in that context becomes practically difficult for, say, the tax authorities to challenge. Another example is, for instance, in the EPC space, where there's currently an excess amount of equipment, bulldozers and cranes and so on. They're actually thinking about how to acquire those assets and export them quickly, if they can, so that once they're disposed of in the international marketplace, it's also effectively challenging for the tax authorities to invest the time to go after it. So it's also, as you can see, a challenge in the asset sphere.
I just want to emphasize how important those 2 points are, that one of the most, and correct if I'm wrong, Judge Gonzalez, but one of the most important developments in bankruptcy law over the past 20 years has been the rise of going concern sales through Section 363 of the Code. They are incredibly fast. You can see it even in the data. The typical Chapter 11 case took about 2 years. If you look 20 or so years ago, that the median case takes 9 months. And in large part, that's because asset sales occur so quickly. They can occur within, in a case of Chrysler, it was it 30 to 45 days?
It was 40 days.
40 days. I mean, that's radically fast, but that's not uncommon. There are many that can be teed up to be very, very quick. And the reason they're quick is because the whole theory of 363 is you get the assets out, move them to someone who can handle them better, and you leave behind the mess of figuring out who gets paid what. And if you reverse that, as you're saying happens in Brazil, that kind of defeats kind of one of the major innovations of 363. The other innovation is just, in the United States, if you sell assets, it's free and clear. Like the buyer doesn't have to worry about any trailing liabilities. No one's going to be able to sue the buyer on account of what was done by the seller, but that's not completely the case either. So those are, in some sense, that in some sense is the 363 development is so important in the United States, and yet it seems like there are some constraints on that having as much of a transformative influence in Brazil. I was wondering if we can bring you into the conversation, Richard, and talk about cross-border. Like one of the innovations in United States law and in world insolvency law has been the rise of a protocol for cross-border insolvency situations. And what I mean by that is, imagine a situation where you have a Brazilian headquartered corporation that has operations in Brazil, but also has operations in the United States or assets in the United States. Those assets could be land, it could be cash, it could be a bunch of different things. When the Brazilian company files for bankruptcy in Brazil, what about those assets in the United States? Typically, the Brazilian firm or some trustee of the firm is going to come to the United States and seek help in collecting those assets, administering those assets, getting them back from people who shouldn't have those assets. And that's something we call Chapter 15. There's an international protocol for this now. And I wonder if you could talk about, in your experience, is there anything distinctive about that, or any issues that arise that are distinctive with respect to Brazilian companies in the Chapter 15 setting?
Well, yeah, there's a lot of, I would say a lot of common themes in cross-border, and there have been several themes that have become prominent with obtaining recognition of Brazilian proceedings in the United States. I guess the first question is why do you need recognition in the United States? And I think you already raised the first issue, which is, somebody has Brazilian company X owns Blackacre, it goes into an insolvency proceeding, and there's a trustee, perhaps, that's appointed in Brazil, wants to sell the property in the United States. Who wants to buy that piece of property? Well, because when I go down and do a title search, I don't see the name of the trustee on the title records. And so I'm not going to give that guy money unless I know that the title is actually going to transfer. So Chapter 15 provides a mechanism which gives the trustee, if the trustee is recognized in the United States as a foreign representative, they're called, a power with approval of the bankruptcy court in the United States to sell the property and take the proceeds back to Brazil. So that might be the first reason that you would want to have recognition in the United States. A second reason is a lot of times the actors that you need to act in order to effectuate or implement a Brazilian plan won't do so just on the basis of Brazilian law. They want to have the assurance, either they want to have an indemnity, which a bankrupt company is not really in a position to give, or they want to have the assurance of a U.S. court order that sort of blesses whatever action you're asking them to take. So that's another good reason to obtain recognition.
So the fear is that I'm doing something that the Brazilian court, I'm in the United States, I'm doing something that the Brazilian court says I should do, but I'm doing it to another U.S. entity, and my worry is that if that other U.S. entity gets upset about it, I'm not going to get much cover in U.S. court by saying, well, I was just following Brazilian law. Is that the idea?
Yeah, I think that's the idea. Traditionally, before we had Chapter 15 and before we had its predecessor statute, Section 304 of the Bankruptcy Code, and even today, the courts operate on a notion called comity, which is in essence, quite discretionary. And so what you'd like to have, there's really two ways to approach these things. You can either let the Brazilian process run its course, and then if somebody sues you in the United States, you can say, well, here's a Brazilian court order that curbed your rights. And then the question is, will the court where you were sued at go along with that? And it's a matter of comity. And it's one thing if you get sued in the Southern District of New York. It might be another thing if you get sued in, Grant County, Washington court, that doesn't know anything about Brazilian law, is not used to cross-border transactions. The judge was a judge because he was a good prosecutor at some point. Whereas if you have a United States bankruptcy court in the Southern District of New York, they're very familiar with commercial transactions, with insolvency law, with cross-border actions. You're more likely to get your relief beforehand. And that way, if somebody sues you later, you have not only the Brazilian court order, but you also have a United States bankruptcy court order, which pretty much every judge in America understands.
Right.
And once you have that order, then you can get somebody like an indenture trustee, who's in charge of an issuance of U.S. dollar-denominated New York governed notes that the Brazilian company issued. You can get that trustee to take the actions that you wish it to take to implement the Brazilian plan. And the same goes. There's an outfit called the DTC, which is most bond debt is held in a global note form. And I don't know how many of you already took Article 8 of the UCC, probably not that many. But essentially, if you hold bonds, you don't really hold bonds. You have what's called a security entitlement. So basically, you have an indirect interest in the bonds through an indirect holding system. And in order to make sure that everything gets implemented the way it should be, you need the cooperation of the actual global note holder, who only has a beneficial interest in the economic rights, but nevertheless is going to want to have the protection of a court order, a U.S. court order, in order to act.
Richard, what you meant, I think one of the major distinctions, even if every single court that you went to in the United States would, I couldn't get it to go on.
Here, Mr. Zaris.
I want to use that one.
Thank you. I think even if every court, outside of Section 304, which was a predecessor to Chapter 15 and Chapter 15, if you relied solely on comity, so you have a confirmation order out of Brazil that says, this is what the creditors get, they're thereafter enjoined from pursuing the debtor, and some creditor commences a litigation in a district court or in any court in the United States, the most you're going to get on comity would be to stop that specific litigation. You're not likely, absent 304 or now Chapter 15, ever going to get comity, a judge, to say, okay, I'll grant comity to the confirmation order, and you now have a U.S. injunction. So regardless of whether the court would see things your way, outside of Chapter 15 and then prior 304, you were very limited in what you could do to get kind of broad-based relief. And absent that, you'd have to run around with your confirmation order to every single litigation and say, stop it. So that's where I think 15, now certainly 304 earlier, provides really a very important tool for the foreign entity to get relief, in a country that will follow the model law, which is now Chapter 15 here.
And I think that the jurisprudence that we have under Chapter 15 and before that 304 is just more advanced, and it's really federal jurisprudence. If you went to a state court is likely to turn to state law of comity, which probably is the old version of comity, could be the old version of comity. We do have recent New York state court law that employs sort of the federal notion that we have now, but the traditional notion was we'll give recognition to the foreign order after we've taken care of the local creditors. If there's anything left over, then we'll give that to the foreign trustee, and they can deal with it however Brazilian law says to deal with it. You know, as late as 1960, there's a New York court decision out of Buffalo where a Canadian, a natural person, but nevertheless, obtained a discharge in Canada through bankruptcy and was sued in New York, and the New York court said, well, you know, that's good in Canada, it's no good here. Basically, if it was a New York debt, then the Canadian courts had no jurisdiction over it, really, as against U.S. creditors. That's the way that they saw it. There was a case back in I think in the 1880s, Supreme Court case that sort of started to change that thinking, and that's sort of been the basis of recognition of foreign discharges ever since then. But I can't guarantee that every court, every state, you know, recognizes that. I can't even say that New York recognized it until recently, because that was before Erie. So I don't know if they were applying New York law or federal law or what. So so it can be a great problem. And then the question is, once you see why you need it, then the question is, can you get it? And what are the reasons that you might not be able to get it? And you know, the courts have basically said there's different terminology used in Chapter 15: sufficient protection, or not against public policy. But basically, I think Judge Gonzalez will know better than I do, perhaps. But I think what the courts are looking for is, you know, was the foreign proceeding fundamentally fair? Did it have due process? It's an impartial tribunal. Was there sufficient notice given and an opportunity to be heard? Are U.S. creditors discriminated against in any way? Did the court have jurisdiction under its own law, and is that jurisdiction reasonable under international norms? Those are the sorts of things I think the first set of questions a court has, a U.S. bankruptcy court would have. Then when it comes to the substantive law, I think a great deal of deference is given to the foreign law. There's a few touchy areas, what I would call them. One sort of pattern that I've sort of discerned is when it comes to property rights. The U.S. courts are less willing, I think, to give deference. So, for example, there was a case out of Germany about whether or not patents could be transferred, intellectual property rights, whether intellectual property rights license could just be rejected. Under German law, it could. Under U.S. law, if it had been a Chapter 11 case, that would not have been allowed. And the courts did not allow it. Did not allow the German trustee to pursue that in the United States because there were property rights involved. With respect to Brazil, the sorts of things that have been objected to so far, not particularly successfully, but are the ones that we've been talking about. The perhaps more liberal view of substantive consolidation. I think one of the most interesting ones is this notion of absolute priority. I'm not sure if I'm talking to bankruptcy students or not, but it's the idea that equity is not allowed to recover until creditors have recovered in full, and that's unless there's consent, of course. That's more or less a bedrock principle in the United States since the 40s, at least. But in Brazil, it doesn't necessarily work out that way. It doesn't work out that way, and so that was a big challenge. But here, the courts have accepted that absolute priority does not necessarily, you can be a civilized You can have a civilized judicial system without having absolute priority.
Can I jump in there and use that as a springboard to think about, in the time we have left, to think about what are the I mean, in some sense, the spirit of the conversation is that there's been a lot of evolution in U.S. law from the 40s with the adoption of or formal adoption of the absolute priority rule through the 363 sales we talked about, with the growth of creditor control through secured lending, through active trading in debt markets. A lot of things have transformed the bankruptcy process. And one of the games you play is like, what does the future look like? What things are likely to change? And I'd like to play that game with Brazil. Like right now, what are the developments, or what areas of law produce the greatest uncertainty, or what areas of law do you predict will be the subject of the most evolution going forward? And I think that's actually particularly interesting now, and after 2 years of a crisis in Brazil with an incredible increase in number of bankruptcy filings. I would suspect that the jurisprudence is evolving, as it typically does during a crisis. And so if you were to sort of say, look into your looking glass, try to think about the future, try to tell people in the audience like what to look for, what are the future trends, what would you think, what should they think about going forward in Brazil?
Can I? Yeah. We do have an amendment of the law being discussed in Brazil right now. It's been discussed in Congress, and lots of professors and lawyers, they are discussing the amendment of the law. One of the points that we should see some progress is in the cross-border issue in Brazil. Brazil has not adopted any kind of the model law, so we don't have a similar Chapter 15 there. We just don't recognize any decision in a bankruptcy case abroad. So one of the issues this amendment of the law is trying to tackle is for us to have a cross-border mechanism to accept foreign decisions like the Chapter 15 here. We also, after many years of crisis, what I see is that, at least in São Paulo, the biggest city in Brazil, we do have specialized courts. We have 4 really good judges there. There are also professors. They study a lot. They travel a lot to try to understand foreign bankruptcy laws. And we are, in my view, we are start to seeing some trend of stabilization that I think is really important for all the players in the restructuring world. At least in São Paulo, the State Court of Appeals was able to achieve a really good set of judges to rule on the most important and big cases in Brazil.
One area that I think we'll probably see more activity in Brazil is actually an area where we've been talking about a lot of ways in which the Brazilian system has not caught up to the U.S. system, or has some you can say deficiencies relative to the U.S. system. I think there's one area where I think actually they have it right, or they have a really good system, which is called extrajudicial proceedings. So in the United States, there's a concept of a prepackaged Chapter 11. The idea there is before a company files, if it's able to negotiate a plan with all of its creditors and get the requisite consents and support levels that it needs, actually solicit votes on that plan so that when it files, the company spends the least amount of time in bankruptcy possible, and it files, and on day one it presents to the court, here's my plan. I don't need months to figure this out. I figured it out already, and I've got the votes, and let's just go through the statutory process to get it confirmed, which will take 45, 60 days. However, in Brazil, there's this extrajudicial proceeding concept, which streamlines that much more. And the way it works in Brazil is if you have a class of similarly situated creditors, so they rank pari to each other, all hold the same instrument, for example, and you have the support of at least 60% of that class, of that group, to modify the terms of that instrument that they own, regardless of what the thresholds of that instrument's contract itself, say, are required for amendment purposes. Putting that to the side, if you've got at least 60% support, then you can go to the court in Brazil and have those terms amended only with respect to that instrument, only with respect to that class. The company doesn't have to trigger a default across its entire capital structure, deal with all of its creditors. In the United States, there is no analog for that. Either out of court, you either have complied with the amendment thresholds of the debt contract that you're trying to amend, but if you're not able to, then you have to go through the entire Chapter 11 creditor impairment process and figure that all out. In Brazil, there's this analog, there's this ability to do it via a much more streamlined fashion, much more surgical fashion that just targets the instrument that might be causing the problem to the company.
Just to make sure, so if in my hypothetical, the parent company has issued bonds held internationally, those bonds can be restructured with 60% consent. You don't need unanimous consent?
That's correct.
Even if the indenture itself requires unanimity?
Correct.
That's right.
I mean,
That's correct. And you can do that without, let's say that, that has a complex capital structure like you hypothesized. In the United States, everyone would be brought into that proceeding. You have to get consent of everyone, comply with all the voting thresholds that are necessary in Chapter 11. In Brazil, no. You could say, look, this is my problem area. I'm going to put a fence around it, deal with that with my 60% level, and everyone else can just, I don't have to touch the rest of the capital
It's
structure.
hard to emphasize like how huge of a difference that is. In the United States, we have something called the Trust Indenture Act. It applies to bonds, but a lot of bank debt has the same provisions. And what it says is that you can't touch the Holy Trinity, which is the term of the bond, the principal of the bond, and the coupon rate, the interest rate on the bond. You can't touch those without unanimous consent. And many people, including one of our former colleagues, Mark Rowe, have hypothesized that like this Trust Indenture Act, which dates to Great Depression times, actually drives firms into bankruptcy because how often are you going to get unanimous consent to a bond workout? Now, 60%, that's
Much more achievable.
Yeah,
that's a radical difference.
It would be, the two thoughts come to mind. One, would that get enforced in the U.S.? How would you do that? Could you file a Chapter 15? Is it a collective action proceeding? Is it a foreign bankruptcy proceeding? The other thought that comes to mind, totally unrelated to Chapter 11 and Brazil, but in the statute that was enacted to aid Puerto Rico, and as a member of the Oversight Board, I've had to read it a number of times, they do have a section which is quite unique and very similar to that. They have a Title VI, which can restructure the debt in spite of what the instrument may say, and you go to court with a requisite number of requisite amount of support, and you can restructure that debt. But it is limited to this statute, and I know of no impetus that anyone's trying to expand it broadly. But that's the only example I know of in which you can impose, outside of the full bankruptcy, a structure on the debt.
I was just going to point out that in the Great Depression, they consider that a feature and not a bug. I mean, the reason of for the Trust Indenture Act was to force a bankruptcy because there was perceived abuse before that time that investment bankers and lawyers got together and sort of gave a raw deal to the little guy.
Can I push you on this? Just like, let's take Judge Gonzalez's point that suppose that firm is in bankruptcy. No, so a Brazilian firm has gone through this extrajudicial proceeding, gotten 60% of bondholders, and let's suppose that 60% are all Brazilian, and the other 40% are in the United States. The 60% in Brazil have voted to reduce the principal balance. You're owed 100, you only owe 40 now. So, and let's suppose that this Brazilian firm also has assets in the United States, and the American bondholders want to take steps to enforce their rights to the full 100, not to reduce 40, the full 100 against the assets in the United States. And so a trustee from Brazil goes to a U.S. court and says, I want your help, U.S. court, in enforcing this Brazilian judgment, which is reducing the bondholders' rights to 40. So where we thought Ricardo was trying to get 100 in the United States from my assets, he should only get 40 because that's what we did in Brazil. would that be respected in the United States? Would a United States court help enforce this extrajudicial proceeding in Brazil that is enforcing a law that seems antithetical to what we think about in the United States? We talk about the Holy Trinity, and they just blew that out of the water.
Is it TIA qualified? That's the first question. If it's a, if it's a Brazilian law issued a bond that's, or even an American.
Let's just say it's in the indenture. Let's suppose that the indenture itself, whether qualified or not, says that you need unanimous consent.
Well, I mean, the difference is, just to be clear, the TIA governs a TIA qualified indenture no matter what's in the indenture.
Sure.
And it's a matter of statute, not merely a matter of contract. Whereas without that, it's only a matter of contract. And so that makes it much easier, because the whole point of an insolvency proceeding is to restructure contracts. And that's what will have occurred. Now, I suppose the lower your threshold becomes, the more carefully the U.S. court is going to look at it. But where there's a more direct conflict, if the foreign company, if the Brazilian company has issued a TIA qualified U.S. style indenture, then I think the court has a real dilemma. And I think it's a real matter of controversy, because on the one hand, you might have Chapter 15, which tells the court, well, give comity, if you can, to a Brazilian insolvency proceeding. But on the other hand, you've got a U.S. statute that says this cannot be changed. And likely that is the very reason that debt instrument was used, and the creditors who bought it, who purchased those bonds, relied on it.
Yeah, but we do have some cases in Brazil that extrajudicial proceedings, not like your example, of course, but worked out with some of the bondholders here. The necessary threshold, the 60% of the bondholders worked out with a Brazilian company. The Brazilian company filed for the extrajudicial proceeding. It got confirmed in Brazil, and the debtor brought the case to the U.S., and it was confirmed here in the Chapter 15. Of course, it wasn't a case like only Brazilian creditors were trying to cram down American creditors, but it's like...
I wanted to make it dramatic.
Yeah, no, of course.
But before we conclude, can I ask, just give Fred a chance. When you looked into your crystal ball, or looking into it right now, what do you think is likely to be on the frontier for evolution in Brazil?
Well, there's a flip side to the coin on this trust indenture act discussion, because while on the one hand it works or has worked in the context of an extrajudicial proceeding, it actually creates the opposite problem for foreign investors in a judicial recovery, in a recuperação judicial, where effectively the Brazilian courts have decided that where unanimous consent is required, the trustee of the bond cannot actually vote on behalf of the bondholders, which effectively requires the bondholders to go through what is a very expensive and bureaucratic process of individualizing their claims, appointing local counsel to represent them in the judicial recovery process in Brazil. And while that may work fine for a hedge fund or a large institutional investor, it has the effect of basically disenfranchising individual holders. And there's one case in particular right now, a very large one, where you have billions of dollars of bonds that are held by individual investors in Europe, and they haven't found a way to effectively organize themselves and be represented in the Brazilian process. So unfortunately, while it's attractive in one case, it's a problem in another, and I think this is one area where there's work, I'm told, being done to improve the system. There are also maybe two issues that we may not see much progress on in the upcoming changes to the law. One is the issue of tax. Tax in Brazil, because of the way companies typically go into bankruptcy, where they stop paying taxes well in advance of filing as a way to preserve liquidity. And also culturally, the older the companies are, paying tax was not always considered a requirement by business owners. So,
Optional tax.
right. So they go into a judicial restructuring, and tax is outside of the process. And the Brazilian IRS, they're not really interested in renegotiating these tax claims, or renegotiating them in a way where you have the adequate haircuts you need and the cash flows necessary. And so just like in the case of the bank debt where there's no haircuts, the same would apply to tax. And it's a big issue, and I'm not sure it's going to get solved. And maybe the last one is the area of fiduciary liens. Bruno mentioned they're outside of the process as well. And so, for example, if you're a bank and you have a mortgage on a key asset of the company, you can go ahead and execute that mortgage extrajudiciously, which creates a problem, obviously, for the bankruptcy plan. I think there have been some cases now where judges are questioning whether preserving the estate comes ahead of being able to execute the fiduciary lien, which actually creates a problem for the interpretation of the law of whether the fiduciary lien is actually worth anything. It would be nice to see that reconciled. What I've heard recently, I was just talking to folks down there last week, is that the banks are really resisting allowing the fiduciary liens to be brought into the system, because they're afraid of other ways that might lead to perverse outcomes. So anyway, I think those were kind of the 3 points.
Well, don't want to conclude without giving Judge Gonzalez. If you have any, do you have any final thoughts, Judge?
No, I mean, my thought is a lot of what I think we do in success that has, at least it seems that the world looking at the U.S. system looks at it as a successful system to preserve value, I think has an awful lot to do with predictability and reliability, not so much of the outcome, but at least the standards within which the outcome will be determined. And I think that's a worthy goal for any judicial system, any legal system. And I think that would go a great deal to advance any system, because investors want to know what happens when things go bad. And they want to be able to at least handicap what the high and low risks are. And I think our system generally has provided that. And I think systems that do provide that, the cost of capital becomes lessened.
Well, I want to thank you, panelists, for joining us up here at Columbia and for a stimulating panel. And I hope all of you got as much out of this as I did. And let's offer a round of applause.